Today's question comes from Milwaukee, Wisconsin, and the reader asks the following. What happens if power of attorney was not signed by witnesses and not notarized? My father gave my mom full finances and medical power of attorney in 2017. However, there are no witness signatures, it is not notarized, and it has not been filed with the court. This is something that he did trying to protect my mom and ensure that his wishes were followed. He was not aware that witnesses and a notary was needed if he signed it. In 2018, my dad was diagnosed with terminal cancer. Due to him being in home hospice care, I'm going to assume he is no longer legally able to create another POA and have the witness and notary added to it. He has property that needs to be sold, various bank accounts, and stocks, bonds. What can my mom do to ensure that she can sell my dad's property, gain control over stocks and bonds and all finances that do not have a beneficiary listed? So first of all, I'm sorry to hear about this situation with your father and his declining health. For a power of attorney for finances, it does not require two witnesses to be valid. The power of attorney for health care does require two disinterested witnesses, and the statutes say they can't be a health care provider. But the financial power of attorney, generally with my clients, they sign it in front of me and I notarize it. Notarizing the power of attorney creates the presumption that the signature is valid, so we do that to avoid situations of fraud, someone forging a signature. And it's good practice to do so. But you potentially have a valid power of attorney if he did sign it and intended to sign it for financial power of attorney reasons. The trouble is you will likely get some pushback from the banks and other financial institutions when you try to use it, because they are so used to the common practice of having it notarized. So the thing is, the fact that he's in home hospice care does not mean for sure that he could not execute a new power of attorney. The relevant case law here says that if your father has a lucid interval or a moment where he has full capacity, he could sign a new power of attorney. And just the fact that he's suffering from a health condition does not mean he's mentally incompetent. So in order to execute a new power of attorney, all he needs is the mental competency to be aware of his actions and what he's doing and want to do so. So if you think he's still mentally competent and your father thinks so, he could execute a new power of attorney, and you could do it in front of a notary just to help you avoid those questions you may have if you try to use the unnotarized power of attorney for finances. So great question on the differences in the law here on what's required between a financial power of attorney and a healthcare power of attorney. And good luck to you with helping work this out for your father and your mother. Great question, and thank you for asking.